So, you're going to small claims court without a lawyer and you want to win? Maybe someone owes you money. Maybe you paid for something and didn't get what you were promised. Maybe your landlord won't return your security deposit or a contractor bailed halfway through the job. Whatever the reason, you've decided enough is enough. You're ready to fight for what's right. But here's the catch. You're doing it without a lawyer. And now you're wondering, how do I actually win in small claims court if I'm on my own? If that's the question spinning in your head, then this episode is exactly what you need. Because today we're walking step by step through how to walk into that courtroom feeling calm, confident, and totally prepared. Even if you've never been to court before in your life, I'm going to show you how to build a solid case, avoid the common mistakes that trip people up, and make a great impression on the judge, all without hiring an attorney. So grab a coffee, take a breath, and stick with me. By the time we're done, you'll know exactly what to do to give yourself the best possible shot at winning your small claims case. And real quick, just so we're clear, this is legal information, not legal advice. If you've got a unique or complicated situation, it's always smart to talk to a licensed attorney in your state. All right, let's get into it. Here's the first thing you need to know. You don't need a law degree to win in small claims court, but you do need to prepare like it matters. This isn't a Netflix courtroom drama. Judges in small claims court don't want theatrics. They want the truth, told clearly, backed by facts, and supported by evidence. Let's say your roommate bailed on rent and left you hanging for $800. It's not worth hiring a lawyer over, but that money still hurts. So you take them to small claims. When your case gets called, you want to be the person who walks up with their facts in order, documents in hand, and zero panic in their voice. That's what wins. So here's what that kind of preparation actually looks like. First, know your timeline inside and out. Write down the key dates. When did the agreement happen? When did things go wrong? When did you try to fix it? When did they stop responding? Be ready to explain the sequence of events in a way that makes it crystal clear who dropped the ball and when. Second, collect your receipts, literally and figuratively. You'll need proof. That can be anything from a signed agreement to text messages, Venmo transactions, screenshots, bank records, emails, photos, or even voice notes. I once saw someone win a case because they had a screenshot of a Facebook message where the other person admitted fault. That was the whole case. And here's a power move. Organize your evidence into a little folder or binder. Use tabs or color coding to keep it neat. Judges appreciate when everything's easy to follow. It shows respect for the process and it saves time. Third, make 3 copies of everything. One for you, one for the judge, one for the other side. If you forget that, you might look unprepared or worse. You could delay your case or irritate the judge. You do not want the judge annoyed before your case even starts. Now let's talk about how you show up. And yeah, I'm talking about your outfit. I know it sounds trivial, but showing up in court dressed like you're going to brunch with friends? Not the move. You don't have to wear a suit, but you should look clean and respectful. Think button-down shirt, clean shoes, nothing flashy or distracting. Avoid big logos, wild prints, or anything that screams, "I just rolled out of bed." Why? Because judges are people too. If you walk in looking sharp and put together, it subtly tells them, "I care, I'm serious, I respect this process." It's small, but it matters. Now, this one's big. Be on time. Actually, be early. I've seen people lose their cases before they even got a chance to speak because they showed up late and the judge had already moved on. You never want your first impression to be, "Sorry, traffic was bad." Plan your route. Know where to park. Arrive 15 to 20 minutes early so you can breathe and settle in. All right, so now your case is called. You stand up, you're a little nervous, but you're ready. Here's the golden rule. Be clear, be brief, be calm. This isn't your chance to vent for 20 minutes. You want to focus on your top 4 or 5 points. Think of it like this. What happened? Why is it unfair or unjust? What proof do I have? What do I want the court to do? And that's it. Don't try to tell your life story. Don't go off on a tangent about what a terrible person they are. Stick to what the judge needs to hear. Let me give you an example. Let's say you paid someone $500 to build a website and they never delivered. Don't say, "I hired this guy and we were texting and I think he had a lot of personal issues going on and I feel like maybe he was overwhelmed, but he definitely promised me something and nah, cut that." Say this instead. "I paid the defendant $500 on January 12th to deliver a website by February 1st. As of today, I've received nothing. I followed up multiple times. I've included screenshots of our agreement and my payment. I'm asking for the full amount refunded." Boom. That's how you win. And when it's the other person's turn to talk, don't interrupt, even if they lie, even if they twist your words. Just take notes and respond when it's your turn. The judge will notice that you're staying calm and collected, and they'll appreciate it. Judges notice behavior. If they see you being respectful and the other person being dramatic or rude, guess who's already winning before the verdict? Also, pro tip, If it feels like the judge is already leaning your way, stop talking. Seriously, don't keep arguing once the momentum's on your side. You might say something that accidentally gives the other side room to argue back. Just let it land and zip it. Then comes your final statement. Make it count. This is your chance to wrap it up with a bow. Keep it simple. Something like, Your Honor, I believe I've provided clear proof that I paid for a service that was never delivered. I followed up in good faith, and I'm asking the court to help me recover my money. Short, clear, done. Now, one last thing that a lot of people forget. You have to prove your damages. That means if you're asking for $1,000, you can't just say, they owe me $1,000. You need to show where that number comes from. Bring receipts, contracts, payment records, whatever backs up your claim. Even if it's something like replacing a damaged laptop, show the invoice. If it's lost wages, show your pay stubs. The judge needs concrete numbers. And if you can, and this is optional but powerful, reference a law or court rule that supports your case. Just saying something like, according to the tenant-landlord code in my state, landlords must return a deposit within 30 days. That kind of sentence shows you did your homework. It makes you look serious. You might be thinking, but what if the other person brings up something unexpected? Great question. That's why part of preparation means imagining what they might say and being ready for it. If they say, well, I never promised that, you can pull out a screenshot. If they say, they never contacted me, you show the emails. That's how you stay one step ahead. Also, don't be afraid to bring a witness. If someone else saw what happened or heard the agreement being made, they can absolutely come with you and testify. Even a short statement from a third party can go a long way toward backing you up. Now let's shift gears real quick, because winning your case doesn't always mean the story is over. Sometimes the hardest part comes after the judge rules in your favor. Let's say you win. Great. The judge agrees with you, awards you damages, and you walk out feeling vindicated. But what if the other person just doesn't pay? That's where post-judgment collection comes in. See, small claims court gives you a judgment, but it doesn't collect the money for you. It's your job to enforce that judgment. Depending on your state, you might be able to garnish wages, put a lien on property, or even request a bank levy. But you'll need to file the right paperwork. Some states let you file what's called a judgment debtor exam, where you bring the person back to court to explain why they haven't paid. It's kind of like calling them in for a financial interrogation. It can be very effective. The good news is, once you have that judgment in hand, the law is on your side. You just need to follow up. In some cases, people pay up as soon as they get the judgment notice. In others, it might take a few extra steps, but don't give up. Also, and this is super important, judgments have expiration dates. They're usually valid for several years, but you might need to renew them before they expire. So if you don't collect right away, put a reminder on your calendar. Keep that judgment alive. And one last thing on this. Keep records of every attempt you make to collect. Every email, call, mailed letter, all of it. If the case ever comes back to court, or if you ask the judge for help enforcing payment, having that paper trail will help you look responsible and reasonable. So, what's the takeaway here? You can win in small claims court without a lawyer. Tons of people do. But the ones who win, they're not just hoping for justice. They prepare for it. They know their facts. They have evidence. They speak clearly. They stay calm. They respect the process. And they walk out with their heads held high, win or lose, because they showed up and stood their ground. If you remember nothing else from this episode, let it be this. Small claims court is your chance to be heard, but the judge can only help you if you help them see the truth, clearly and calmly. That's it for today's episode of In Plain Legal Podcast. If this helped, go check out our episode on what to do if a business rips you off and stops responding. We break down how to file a claim and what to do if someone ghosts you after taking your money. And hey, one last reminder. This is legal information, not legal advice. If you're unsure about your specific case, always talk to a licensed attorney in your state. All right, go get that win. You've got this.